Good evening, everyone, and welcome to Heritage University. My name is Melissa Rogers, and I am so grateful that you've joined us. I help oversee our business development team here for Heritage Property Management. And tonight we are in a 7-part series of understanding community associations, and we're in part 3. Where tonight we're going to talk about all things the Declaration. I really sincerely hope that I'm going to maintain your attention throughout this presentation because this is going to be some pretty dry content, friends. So I really do hope that you stick along with us. Everybody's going to get a copy of the slides from tonight's presentation, along with any resources that we might decide to deliver after our conversations. We will be talking about community associations in general, but please understand we are talking strictly in a general capacity. So if you hear anything today that perks your interest for question about your association's application, we sincerely suggest that you get in touch with your community manager if you partner with a community management company, or your association's attorney. We will be taking questions as I go throughout the presentation tonight. So the Q&A is going to be located in the upper right-hand corner of your screen, or maybe even the middle of your screen. Feel free to drop your questions in as I go through the slides. We'll go ahead and do the Q&A afterwards. And thank you again for joining us. If you've not been part of the series or the other 2 classes, not to worry, we will actually have those hopefully uploaded to our YouTube page a little bit later this year, and we've got the links available for you. So if you would like to see any of those, feel free to give me a shout out, and I'm going to give you my contact information at the end of our presentation. So diving into the fun, tonight we are going to learn all things, like I said, the Declaration, if you will, or really what constitutes a community association, what is a governing document, how governing documents present rules and regulations, and we're going to talk a little bit about enforcement procedures and taking the fair and balanced approach to community association management. So, what is a community association? I get this question a lot. It can be a lot of different things, but generally speaking, a community association is a group of homeowners who wish to provide a communal basis of preserving, maintaining, and enhancing their property values, right? That's what a community association is truly responsible for. That's what the board of directors are tasked with carrying out as far as their duties. And we learned that in section 2 of this series. So here are the basics. The defining characteristics of a community association are going to be that mandatory membership, okay? The governing documents for the land records, essentially, and then assessments, because you are going to be responsible for the common areas of the association. Okay, so don't forget, your community association is a domestic not-for-profit corporation registered with the Georgia Secretary of State. Okay, so community associations combine the characteristics and activities of local government, business, and a community, especially as we talk about enforcement in a little bit. This can sometimes be incredibly difficult for boards of directors and homeowners truly to have good comprehension of, because it can feel very restricting in certain ways when we're talking about implementing fair, balanced practices. Okay, so because of this, it provides a key role in administering, maintaining, enhancing residential real estate development. The community association accomplishes these things through the establishment of a system of property rights, binding covenants and restrictions, and then rules and regulations. So this is the operations manual, essentially. These documents that we're going to talk about are the operations manual of your association's success. Now, some of your associations also are subject to the Georgia Condominium Act. Some of your associations are subject to the Georgia Property Owners Act. And then some, if your declarations are silent in certain areas, are going to revert back to that Georgia Not-for-Profit Corporation Code. So This is a really quick glance of what the hierarchy of governing documents are. The recorded map, plat, or plan. This is absolutely necessary for every condominium association. Now, it's very necessary when you're dealing with master plan communities because you have to have that approval from the land manager of that location, or the municipality has to approve the plats in order to be able to have the zoning rights to go ahead and have construction. As we talked about, these are the binding regulations for the land restrictions, which are going to be the declaration, the bylaws, which regulate the board of directors, maybe any rules or regulations that you have that further outline what your declaration is, the master deed. Sometimes they're affectionately referred to as covenants, conditions, and restrictions, or CC&Rs, okay? And then you've got your articles of incorporation, which are absolutely necessary in the state of Georgia, the bylaws, which we talked about, and resolutions. And so this goes in the hierarchy not only of how to search for information, but also the hierarchy of decision making and authority for the association. All right, so we're going to break down the recorded map, plat, or plan. So some form of map is essential for a condominium or planned community. A map, plat, or plan is even recorded as part of local land records, which I sound like I'm repeating myself, but it is the truth. That's where they're located. Even before any lots or units are sold. Okay, so yes, this is a huge thing, which I was just referring to when we deal with our developer communities or associations that are just starting and they've just purchased the dirt. This is a lot of the conversations that we have, and one of the first things that we tell them that they need to go ahead and get identified is the plat or the plan of the association, or in some cases, the floor plans. Okay, especially if we're dealing with a condominium. Okay, the declaration, CC&Rs, or master deed. A lot of people define these for master plan communities, whereas condominium associations generally just reference a declaration, which we'll get into, and you'll see that. When purchasing a parcel of real estate, the bundle of rights is defined for the new deed and all previous deeds related to the same parcel. Okay, all iterations of the deed are recorded in the county land records. So again, it's not just the land records, it's in the county in which your association presides. Provisions in deeds which define or limit the rights of ownership are often referred to the deed covenants or deed restrictions. Again, it's specifically related to the parcel in which you've purchased. Okay, the legal community references these as running with the land. These documents apply to the land regardless of the past, present, or future owners. It's one of the greatest values that Vanica, if I could just do a quick plug about Vanica, Vanica allows us to be able to track that record for you because the communication stays with the address, not the individual. Very similar in these circumstances. Okay, so these documents are also sometimes referred to from the attorney world as the chain of title. Okay, so if some of these are new items for you, hopefully I'm doing a good job explaining them. If they are not, hopefully I'm doing a great job of explaining them. Okay, so as I just alluded to, instead of asserting the same documents or covenants and restrictions, each individual deed in a community development, the developer draws up the declaration for the community, okay? And I know that that sometimes is a point of contention for some associations, but one thing that I always like to say, I even think one of our great attorneys even gave me this idea of thought. No declaration or CC&R is the same. They are snowflakes. Even if you're an association attorney's office that creates declarations for your developer partners, I'm sure you still put some different verbiages in there, or as legislation changes, you might see some different insertions in the newer declarations than some of you that have them from, you know, maybe the 1980s or the 1990s. And I know that that's a point of contention too when we're talking about declarations renewing or declarations having some type of perpetuity. It's very important to pay attention to those. So when the developer records the declaration in the county land records, this is again what we were just talking about. This is how the owners are given this chain of title for each piece of real estate. So here in the state of Georgia, the disclosure is required on the first sale. So this is why it's so important to have all of these pieces of information pass along with each lot, not just the individual owner. And again, your homeowners are offered this information at the closing table, or whenever you feel it fun, you can actually go on your county land records. There's Q Public or the GIS, which is those are two great websites for your county tax assessor to go ahead and see what your community looks like, or what your particular parcel has as far as the information or the master deed that's attached to it. So for condominiums, we talked about this is called a declaration or a master deed. And then for planned communities, oftentimes people refer to a set of covenants or the CC&Rs. And then there are some that do refer to the declaration itself. So as we see, it establishes the standards. It talks about the relationship for the ownership versus the association. It talks about the rights and responsibilities along with the obligations for assessments, maybe even the computation, the community-wide standard, all kinds of fun stuff in here, okay? Now we're going to talk about the articles of incorporation. So this is the piece of information or the document essentially that brings the corporation into existence. As I said, with Georgia, you are a domestic not-for-profit and you're registered with the Georgia Secretary of State. So it's going to define the basic purposes and powers. Obviously, most of our community associations do not have any stock so much as that's more related to the owner's individual equity, okay? And then hopefully it will get the association initiated on its plan to go ahead and have the remaining items created, which is now the bylaws. So as we've talked about in some previous classes, or if you've taken an additional Heritage University class, the bylaws regulate the operations of the board of directors, okay? So this is where the board definitely can find, not to be confused that there are other defining authority that might be located inside the declaration as well. But generally speaking, as you can see, the bylaws indicate the voting rights of the members, when the membership meeting is supposed to be called for the association, whether or not committees can be formed and what their responsibilities are. So there are a lot of provisions. So if you as an association are only looking at your declaration, you're missing out because there's part 2 of your guidebook, so to speak, or your operations manual in your bylaws. I've said this before, I think it's a unique fact. Almost always the bylaws are recorded with your governing documents, but there are some few, and it's not a state requirement to actually have the bylaws recorded in the county land records in the same fashion that it would be for your declaration or the plat or the floor plans. Almost always, like I said, almost always the bylaws are recorded, but for a lot of associations that might have some more restrictive declarations, they might have some opportunities within their bylaws if they're not recorded. So definitely get with your association's attorney if you haven't already discussed this as to whether or not they are recorded and if you've got any, desire to do any updates. Okay, so now board resolutions, okay, and I probably should have put board resolutions instead of just resolutions, because that's essentially exactly what these are. Resolutions are outlined and created by the board of directors that may further clarify a particular option that is a delegation of authority for the board of directors. We oftentimes see resolutions in the form of collection policies. Your declaration clearly states that assessments are due at this particular time, and this is the penalty if they're not done. This is the time window and so forth. But a resolution kind of just takes all of that, puts it in layman's terms in addition to the legal description, but it makes it more digestible for your ownership to understand. And when you communicate policies or resolutions like that, you might even have rules and regulations that further outline your declaration's initial use restrictions. Those are almost always often also utilized with the Architectural Control Committee. That is a resolution, whether it's of the Architectural Control or the board, that is very similar, the same thing. We're going to see in an updated slide that resolutions we certainly recommend, as much as you are going to keep all of this information on record as a board, we certainly encourage that you also keep your resolutions on file with your association's attorney, okay? Resolutions do not need to be filed in the county land records like your declaration does, but resolutions do give some outline as to what the board's delegating to other members, whether it's a management company or it is communicating a policy, maybe it's fining authority or something. So your association's attorney should have copies of that. Also, if you are partnering with a professional management company, your community manager needs to have on file all of the resolutions of the board of directors. All right, so talking more about the declaration of a condominium, because the way a condominium is created is a little bit different than the way that a master planned community like an HOA is created. Okay, so declarations are very long legal documents that can be detailed and daunting to read. If any of you have ever tried, some are actually really easy to digest. And the ones that are super confusing, where you see it, say it, something in one spot, but then it contradicts itself in another spot, and you're like, did I read that right? That can sometimes happen pretty often, and we see sometimes, you know, association attorneys having to get involved with the interpretation of declarations, especially when it comes to the ownership related to rights and responsibilities and the association's maintenance responsibilities. So association documents represent the accumulation of many years of experience in forming key guidelines for community associations with the intention of maintaining and building homeowners' quality of life in the community, as well as continually improving the financial investment. So we're going to hear the same, you know, maintaining, enhancing, keeping that value of your association equitable for yourself and for your homeowners. Okay. And just as we're outlining, the next couple of slides are going to be a fantastic checklist so that you're going to be able to know what is in a table of contents. Okay, so thankfully, I am not going to painstakingly go through all of a declaration with you, but it is very important to know that the next 3 slides contain what is often found in a condominium declaration. Now, I don't want to confuse those of you that are homeowners associations or property owners associations. You will very well see a lot of this information located, or chapters such as these located in your declaration as well. But again, very specifically, because there are shared party walls in a condominium, there can be stacked units. It's very important to identify the boundaries of responsibilities as you see right now. You know, any disclosures, as we talked about in a previous slide, how to, you know, compute the assessments. Some condominium associations require a percentage to be calculated for the owners to pay on a monthly basis. And then we see some condominiums where they're divided units, and some homeowners decide to adjoin units. So there are a lot of reiterations, and sometimes within a condominium, you might have a sub-association. So it's very important to go ahead and take a look to see if there are any of those items. Going on to the next one, it's definitely going to talk about insurance responsibilities and the types of insurance required for the condominium. This often is going to also be included with any homeowners associations or master plan communities, especially if you have physical structures on your common areas. It might define some pet restrictions. I know a lot of large scale associations that do have pet restrictions within their community, just like a condominium declaration. Okay. This is the last slide. This is the biggest one, I think, in my opinion, the use restrictions. And I want to clarify again, use restrictions. It is unfortunate that sometimes within a declaration, we have to also outline the things that people cannot do, but it's done with really good purpose so that we can preserve what is happening within the community. And this slide kind of represents that. So we're now going to start jumping into enforcement. And so now that we've taken a look at some of the chapters and the table of contents, if you will, that you can find within a declaration. So we already identified we need to have a plat, or floor plans. We need to have articles of incorporation, especially for condominium association. And then we need to have a declaration or a master deed. Sometimes if you can't find the recorded declaration for your association, try looking for the master deed for the community. And oftentimes the declaration is attached to that. So our multiple years of community management, searching and hunting, both working with attorneys and working with partner clients of association board members. We have learned how to be a little bit thrifty on finding information. Let's face it, only recently within the last 20 years, declarations and databases to find documents electronically exist. So for those of you that have some more aged associations or even historical buildings that you manage, it wouldn't surprise me if you did not have online access on the county land records website. They probably don't have them there. You'd have to go physically to the office and have it printed out. But I know many associations now are getting everything updated electronically. So hopefully you have that for your community. But we understand the wording of a declaration or the initial use restrictions or even your rules and regulations are going to be off-putting. Okay, any type of restriction to somebody's asset is going to be somewhat confrontational, or it could be, right? Some people are very understanding and they have that buy-in of, oh my gosh, I'm sorry that I even had to have a letter come to me. I'm going to replenish that pine straw in that front flowering bed. Thank you for the reminder, and people get that taken care of immediately. And others look at it as you're infringing upon my property and you don't have that authority. Actually, when you're purchasing a piece of parcel or a parcel within an association, you are absolutely lending yourself to the mandatory membership requirements that were outlined. So wording provided is going to sometimes evoke those feelings of implied control, and it's difficult. And being board members, it's difficult to have those conversations, especially when they're your neighbors. Okay, but the intent of the declaration is to place specific use restrictions on the land within a community in order to provide the protection of the appearance of the property value and the enhancement of its value. It's very important. So if that's like the biggest takeaway that you have, board members, if this is something that you would like to communicate to your homeowners that maybe sometimes have a hard time understanding, we do this for the benefit of all. not just for some, okay? And so it's unfortunate. Sometimes we have to manage to the 3%. That there is that adage, there are going to be those homeowners that, are going to be really difficult in gaining compliance because they really feel attacked by their abilities on their particular parcel. And we completely understand that. And compassion is absolutely needed. But this is where we hope to be able to armor you that this is a business. It's not personal. It is professional. And here's why. Okay. So I didn't highlight this in full detail, but I want to let you know that when interpreting declarations or any governing documents, okay, and the governing documents now, you have a healthy understanding that the governing documents oftentimes are going to be referred to as the Articles of Incorporation, the Declaration, and the Bylaws. So those are your governing documents, okay, maybe even your floor plan. So when talking about interpretation, which is the board's responsibility, right, they have to interpret what the SOPs are as outlined in the declaration and then make sure that they enforce them with fair and balanced equality, right? Well, unless you are a dedicated HOA attorney that writes declarations and law verbiage as a profession, subject to interpretation is the person that's interpreting the declaration at that particular time. And some of your declarations have shalls or shoulds, and it's difficult to understand. Well, maybe one person's perspective is this way and another person sees it from this perspective, and well, which one is correct? And this is what we're seeing on this slide. And so we sincerely encourage, and we want to remind all of you that partner with community association managers. We are not attorneys. When it comes to having to interpret your declaration, we're going to tell you that you need to get an attorney. A lawyer that practices law is the only person that can interpret law, okay? Now, most of our declarations, thankfully, are very easily spelled out with the do's and the don'ts and the shalls and the nots. And so creating those collection policies like we talked about earlier, we don't have to interpret anything. We just put it on a piece of paper so that your homeowners have a better understanding and it's all consolidated and everybody's good. We're not having to interpret certain things. But possibly when you're looking at a particular fining policy, you might need interpretation on whether or not you have fining authority other than self-help abatement and specific assessment charges. Your community association manager, and sometimes even you as board of directors, should not be the ones to interpret that specifically, especially if it's very ambiguous or initially incredibly unclear to at least more than one person. However, there are a couple of different schools of thought. And as I said earlier, I oversee new business development for Heritage. And a lot of times I've talked to board members who struggle with these same conversations about enforcement, because let's face it, land restrictions are the most litigious piece of item or anything that you can put for a homeowner or a board of directors. Leasing restrictions, that's a land restriction, okay? Leasing restrictions, very litigious, okay? Enforcement, very litigious. And there are oftentimes incredibly specific procedures that your declaration outlines that you, board of directors, cannot navigate away from, right? Or community managers, when we help create those policies for, the automatic setups of, your late fee letters or your violation status updates. Those we can program, and it's good because you have that consistency. Not everybody shares that same perspective. And so we do have a school of thought that most people believe that if the declaration does not specifically state something, that it is allowed, and then it's basically effectively prohibited, okay? For those that believe that the declaration does not state something that is specifically prohibited, then the circumstances under this might be allowed, right? So sometimes if you've got somebody that says, well, it's not in there, so we can't do it. Well, it's in there, but it's ambiguous, so maybe we can do it. There's sometimes, and a lot of time we see this board of directors have the capability of using good business judgment in being able to have particular one-off circumstances. So we really want to embrace the methodology of the more reasonable approach between the two, right? There is the third strategy, and it's definitely the one that should be avoided, okay? So it's in small writing for a reason, and that's called selective enforcement, okay? And this is when you start to pick apart, well, we're going to do this, but we're not going to do that. Well, you know what? I talked to this homeowner 2 days ago, and that pine straw bale that's in their driveway, they said that they were going to do that. So then let's not go ahead and send them a letter. And then next month that pine straw bale is still there, right? Okay, so that's okay, but if we don't send a letter to this person for their pine straw bale, yet the person with the bag of mulch that needs to be done got letters, you board have the authority to have that discretion, but you need to be prepared in order to defend the reason why you did not give the letter to the pine straw bale and you did give the letter to the mulch. Now, very commonly, I'm sure you all know this, you get the homeowner tit for tat, right? Like, well, my garbage can was pulled out and their garbage can is still right there and I can see it and I know for a fact they didn't get a letter because we had dinner with them last night. Okay, we know your homeowners are going to talk, and there is some protection with that. You cannot talk about other homeowner lots to other homeowners. It is protected. And so the general answer should be is, thank you for bringing that to our attention. We are addressing that homeowner. We are addressing you as a homeowner. Those two do not have anything to do with each other right now. We're going to focus on your concern, right? So just be very careful, but it is very true that the common thought of selective enforcement is out there from time to time. And so it's very important to understand that if you are giving a special circumstance, you must notate that, and you must do so that future board members have a healthy understanding of what's happening or why you made that decision, okay? So even though you might feel if the declaration does not specifically state it, then it's not allowed, okay? Offers the most protection should conflict arise, but the method loses sight of the fact that not every member or situation is identical. So it's now we're tipping the slide. So if it's not in there, then it's not allowed. Well, again, what we're talking about is most governing documents, specifically the bylaws, give the board of directors the authority. Sometimes when we're dealing with rules and regulations, there is the affordability under the architectural control for the Architectural Control Committee or the, Architectural Board Review Committee. There's a lot of different acronyms that you might see, ARB, ARC Committee, lots of modifications committee, okay? Some declarations do allow for the committee members, not the board. Some declarations do allow for the committee members to establish reasonable rules and regulations for the architectural control standards while using the initial use restrictions outlined within the declaration. And why I say that is, if it's not in there, you can't enforce it, meaning if you decide to no longer allow basketball goals, yet your declaration says that basketball goals are allowed, they just need to be stored properly and out of sight line, or they must be in ground, and then all of a sudden the next board 10 years down the line goes, no more, no more basketball goals, period. We don't want them. That's not the nature. That's going to be a really difficult conversation for you to have, and one you certainly are going to need to have with your attorney, because you might even need to amend your declaration for that. So because, again, if your initial use restrictions outlined in your declaration, those are the declaration references needed. So a lot of times board members like to reference the design guidelines or the rules and regulations as to, okay, we can't, they can't have a purple house or whatever. Okay, I'm looking at the color purple, and so then I say that. So they can't have a purple house. It's very important to take a look at what your architectural standards say. If there is a color pattern, if there's not a color pattern, this is the most common one that we see as an example of an appropriate rules and regulation guidance needs to be offered. The initial use restriction says fences are allowed. That's it. Well, as an association, you might want to say fences are allowed, but we would like them to be 6 feet maximum and no chain link. Okay. So long as that is a community-wide standard and you're not allowing chain link on this side and only wood fencing on that side, and you're having some selective enforcement, do we get in trouble? So just make sure if your declaration and your initial use restrictions do not outline anything about leasing, you might not have any leasing authority. So be very careful. There are some associations where we see they exercise power that's not outlined to them simply because they want it to be that way. Oftentimes, if your declaration is void of something, the only way to include it is through amending your declaration. And oftentimes that means a vote of the ownership. So pay very close attention to that. All right. Steps to effective enforcement. Now, this is specifically talking about when you're working with a professional management company. Not everybody has that opportunity to do that. And so it's very important to understand, and I kind of articulated this already throughout some of the previous slides. It is your job to interpret and enforce the declaration, but when it gets to sticky situations, you really want to make sure that you're relying on your association's attorney as well. But the first thing we need to do, especially, and think about this from maybe you're a new board member, okay, and you are just curious about the process, or maybe your association just turned over from declarant developer control, you're the inaugural resident run board, and it's time to create some rules and regulations. Well, it's a good thing that you are talking to us, because we've got fantastic samples. Many of us, attorneys and community association managers, we work with other properties and other partners that have these established guidelines already in place, and we can offer you some references so that you don't have to reinvent the wheel, okay? But the good thing to do is, first and foremost, if you have a set, start with those. Take a look at your governing documents and make sure your declaration authority is existent. Okay, so if you have to be more moderate in your approach and you have to seek an association's attorney, we are able to provide you those examples like I just said, okay? So maybe you have some design guidelines and they're from 10 years ago and they need to be updated, and you want to see what other associations are doing with in implementing a color scheme, even though the developer might not have had one outlined for you. No problem. We're happy to help provide. All you need to do is ask. And again, if you don't partner with a management company, association attorneys have these readily available from their partners as well. Okay, so once the enforcement criteria is established, representatives of the board should consider doing a ride-along. Okay, and I know it's we're still kind of pseudo in the time of COVID, and so it might just be one person at a time, or depending on your condominium, it might physically be walking the building or walking the property. That's a good thing to do. each person looks at different things. We all have different perspectives. And one of the biggest pieces of information I learned early on as a community manager, I managed a lot of large scale associations. And when you're dealing with a lot of homes, you could potentially be dealing with a lot of, courtesy notices. And so one of the things that I learned to do specifically for myself was, okay, I'm going to take a look at the different times of year, because clearly I'm not going to outline landscaping in December when I don't know the difference between a dead plant and a dormant plant. And that is a real example. I had to learn the hard way because I didn't understand that Indian hawthorns go dormant, and I thought it was just a dead bush. And I got educated that day. Haven't made that mistake since. And sometimes that's how it has to go. But oftentimes as community managers, we take a look at seasonal specific items. We keep that in the back of our mind, and then we focus on maybe one or two items. And what I mean is, by focusing, when we focus on roofing shingles or pressure washing, the really egregious items are going to stick out. When we start looking for everything and we have to look for everything on every single home, that's when we miss things. You as homeowners, you get to walk by those homes when you walk your dog. You as condominium owners, you get to walk those floors or ride that elevator and see what's happening at the concierge desk. You oftentimes have a little bit more opportunity to see things consistently. And so we really need to partner with you. Being on a board and working with a management company is a partnership. It's a 50-50. We do not have any decision authority. We have to get the instructions just like you from the declaration and from having outlined procedures such as these. So it's really important to know and partner with us. So I know some people are not a fan of the school of thought of looking at things, seasonally or specific topics. I respect that. And a lot of your community managers will work with you to determine that way and things are done. But doing a ride along like that or a walk along like that, that allows you to see what your manager sees, okay? That allows you to see what your architectural control committee sees. Sometimes you have street captains even, right? And you have people that you help delegate those responsibilities because maybe you don't have a management company. That's a really good thing to do. Walk alongside them so that you know what your peers or what your management company is looking at, and then making sure that the notice that goes to the homeowner for non-compliance has to state the declaration reference, the initial use restriction reference, okay? Oftentimes we also include the rules and regulation reference, but I just want to be very clear with that, okay? And so sometimes the last resort is when all else fails and our ability to provide best business practice or our ability to provide resource to you comes to a point where we're like, yeah, we really need to get an attorney involved. Only then are we going to come to the table to you and say, hey, we might have to spend some money in order to get this done. The last thing that I want to say about effective enforcement, because believe it or not, with as dry as our content has been tonight, and I feel like I've lost control of the ship. There we go. We have actually reached the end of the class, and we're about almost 20 minutes early, thankfully. I knew this was going to be really heavy content for us to digest. I'm not sure if we're going to have a lot of questions, but if we do have questions, I'm happy to go ahead and take those now. But one of the things that I want to kind of close out with more specifically is when you're dealing with violation letters, you need to make sure that you follow what your declaration's outline is for the notice period. Even if your declaration does not require a hearing, if your homeowners request a hearing to be heard about a denial or violation fine that they've received, please give them that courtesy. Even if your declaration doesn't require it, If you have to go to court, as we talked about, these are the most litigious things that you could potentially be subjecting yourself and your homeowners to. Be prepared to have that conversation and go, hey, listen, this is the reason why we're providing consistency. We had to send that second letter so quickly because actually our declaration says you have 10 days to abate before that second notice goes out. We're not trying to be aggressive, but sometimes if you don't follow the letter of the law and you then have to use the law will look at you and go, but you had the opportunity, you chose not to do it. And so maybe the homeowner doesn't have to do it, or maybe the homeowner doesn't have to do it in an immediate time period and they are able to do it, over a period of 6 months. Maybe the court decides to side with the association. So be very particular when it comes to drafting your enforcement procedures. The last thing that I'll say about notices and violation and enforcement procedures: collection policies, rules and regulations, fining policies. If you have those already in your community and you change them or you update them, you must send them out to every single homeowner. You must give them constructive notice that there has been that change. Oftentimes we see amendments are passed to the association, which is great, and it allows for fining authority. But when you adopt fining authority, it doesn't, you're not adopting physical figures, you're just adopting the capability. If you don't further outline what a fee is going to be for a continuous violation or static violation or an egregious modification without approval, if you don't put those figures out to the association, you might risk not being able to enforce that penalty. So always give notice whenever you are making changes. Obviously, if it's the first time that you're creating that policy, then you absolutely are going to send it out to every single homeowner as well. But a lot of boards don't realize that when you make a change even or an update, it does need to be communicated to the association. So, okay, looks like we've got some questions right now. What is the process if homeowners want to amend to a governing document? Want an amendment? Okay, forgive me, I didn't read that. Okay, what is the process if homeowners want an amendment to a governing document? It's a very good question, and that's going to depend specifically on your declaration. So there is an amendment procedure provision that is in a declaration that definitely outlines what the amendment, you might have to have a vote of the association, and some definitely the declaration requires a vote of the association. But as I was referencing, and this is not the norm, trust me when I tell you, it's not the norm. Sometimes when bylaws are not recorded, some amendments to the bylaws might be available through board discretion or board resolution as opposed to an amendment procedure of the association. So very different distinction and delineation. Thank you for asking that question. An amendment will always require a vote of the association, while a resolution is a vote of the board of directors. So definitely take a look specifically at your governing documents to look at that amendment procedure. And sometimes if your bylaws are recorded, there might be an amendment provision in your bylaws that may require a specific procedure be done as well. Okay, we have a few properties that have received violation notices, but the owners have not taken action. Our neighbors in the community are frustrated because it looks like nothing is being done. What can we do? First off, thank you for volunteering on your board. Everybody that is here, you are doing a fantastic job, whether you're watching this live or on replay. I'm sure that this is a very common plight that you all have to navigate as community association professionals. We hear this conversation a lot throughout our boards. Here's what we can say. Sometimes getting code enforcement involved, depending on the nature of the violation, is helpful. Sometimes getting code enforcement involved is not helpful. So do your homework and know what the, and obviously uphold it to the specific issue itself. When we're talking about single family homes, let's just say, and you've got a house that hasn't been painted since the developer initially painted the house 25 years ago, and it's got, you know, shutter that's hanging or even missing perhaps, and it's the eyesore of the community. Or you've got that homeowner that's got that tall grass that's so high that everybody is like, almost looks as if they're real mowing their grass when all they're doing is cutting it because the homeowner's grass next door is just sticking out like a sore thumb. I alluded to there being different types of violations: static, continuing, and then modifications without approval. It's very important that if you do not have any type of fining authority, that be something that you consider for your association, especially if your ownership as a whole is just taking a look at your compliance letters and going, yeah, whatever. If you have board meetings that allow for open discussion, or if you have community town hall meetings, or maybe even at your next annual meeting, communicate to the ownership in a general way. We see what is happening within the association. We are actively communicating with those homeowners to abate the violations present. We are doing everything in accordance to our governing documents to abate the situation. That is all you can say. I understand that that does not help your angry homeowners. It does not help the sometimes perspective of the board from the homeowners. And of course, we want to create an environment within a community of community. And this is why we're talking. Listen, enforcement procedures can be very threatening to a lot of people. And this is one of the biggest reasons why associations partner with management companies, because we are an independent third party that can communicate and kind of be that buffer to your homeowners. So, you know, try to be as open with your homeowners as possible. But again, it is perfectly acceptable for you to say we are doing everything in accordance to our governing documents that we can. If you do not have any penalties, or if you do have fining authority or penalty authority and you are not evoking that as an association, and your association owners are starting to go, oh yeah, they're not going to do anything, they're just going to litter us with paper. That's when you, the board, need to possibly reevaluate your enforcement procedures and maybe put into practice those fining penalties, or possibly amending the declaration so that you have that fining authority. I know that doesn't sound great, but there are ways. And again, if you're a heritage partner, to the person that asked that question, if you're a heritage partner, please get with your community manager and we can talk more offline about this. If not, take my email. Feel free to email me directly. I'd be happy to help you with specific instances. Okay. Do you have a list of documents you suggest to list on our website so that residents have quick access to them? That's a really great question. Okay. So if you are not already a partner of Heritage, you'll see on Vantica that your homeowners have a homeowner folder, and within the folder, your homeowners do have access to specific things. So we recommend as you know, the budget for the year, the balance sheet and the income statement for each month. They don't need to see the transaction detail. They don't have the authority to see the AR aging or the prepaid reports, okay? They don't have the access to see the violation or the collection status, but they should know what the financial position is of the association other than just the budget. But again, if you feel comfortable with the budget for your ownership, that's fine too. Your association governing documents, I mean, like everything. They should have access to be able to see the electronic versions of all governing documents that they are subject to. If you have any forms, so if you have a modification form, or if you have a leasing form, you name it. If you have a registration form or a clubhouse rental, make sure that those forms are readily accessible to your homeowners, okay? So governing documents, they need to be able to see those. Any forms, they need to be able to see those. And any policies, rules, or regulations, as we're talking about right now, they need to know. They need to know what the enforcement procedure or what that fining policy might look like, or if they're late in paying their assessments, what is the board's position on, you know, sending people to court? You might have that listed. So definitely that. Any community broadcasts that you have or any upcoming events, always make those available. Even your previous community broadcasts. A lot of our sited communities or larger associations that have on-site managers, they do a fantastic job of cataloging that, because there's a lot of communication, even in our high-rise buildings too. They allow for the homeowners to be able to go back and see, oh, wow, they talked about this subject. Wow, parking seems to be a reoccurring conversation that we're going to have within the association. Your owners have the ability to see that. The most important thing that your homeowners have to see is the open board meeting minutes of the association. So those are the items that we recommend. Those are the things that absolutely your community owners have the right to see. What we'll include in tonight's bundle of resources, and I think we've kind of included it with all of our resources recently, is the owner rights and responsibilities and the community leaders' rights and responsibilities. That also helps best identify what types of things your homeowners have access to, so that way you can go ahead and provide that to them on that digital capacity. Okay. Would an amendment to the declaration be the same hierarchy as the original declaration of covenants? Yes. What an amendment does is it strikes out what the original governing document states, and it restates or it adds to something that was void or not previously present. So any amendment is part of the declaration. That's a very good question. Oh, and that seems like it was our last question, and these were actually really good. Thank you so much to everybody who stayed and participated in tonight's class. I hope I didn't throw too much information at you or it wasn't too boring, but this is critical information, especially if you're a brand new board member. Understanding and breaking down the basics, that's what this series is. The good news is our series number 4, our next part is going to be in September, and we're going to talk all about rules. So I started to talk about the declaration. Now we understand what the table of contents and what it's supposed to look like and why it's important. We talked about board members, what their responsibility is. We talked about working with a professional management company. We started to talk about enforcement procedures. The next class is going to be nothing but rules. So we're going to go into this in a little bit more, but our very next class is going to be on August 25th, and it's going to be Budget Boot Camp. I am so excited. 'Tis the season, my friends. For all of you doing budgets, bless you. You should hopefully, if you're a Heritage partner, you should be getting a copy of your first rough draft from your community association managers by the end of this month, if not the very beginning of September. And so our class on August 25th is going to get you into shape so that you understand what is coming ahead, how to be able to talk about those capital improvement projects. And then we're going to talk about how to praise yourself a little bit on all of the wonderful completions that you've had, or the tangible objectives that you've been doing this year as a board, and how to get ready for your annual meeting. So join us on August 25th. I'm going to be joined by our Vice President of Accounting, Sharon Moschel. And 2 weeks ago, she just did an awesome treasurer's training class. She was trying to get you preset for the budget season as well. So Heritage University is actually going to have classes every 2 weeks for the next 2 weeks, for the remainder of the month. of the year, excuse me. So obviously this 7-part series is going to take us into the month of October, maybe even November, I think, but we are going to have supplemental classes like the Robert's Rules of Order class in October. I'm so excited about that. Our managers have already taken that class, and so we can't wait to dive in a little bit more to parliamentary procedure to get you prepared for your upcoming annual meetings, or maybe even some community association budget conversations that you're going to have, because let's face it, this is a tough year to talk about budgets and doing some budget preparation. So thank you to everybody that joined us. We look forward to seeing you in the audience really soon. Thanks to the production team for your time. You guys are awesome and for making this happen. For those of you who are interested in taking a look at our previously recorded classes, you are welcome to go to heritageproperty.com, look at our community-focused education, and then it will link you over to our YouTube page where you can see some of our previously recorded courses. I bid you all farewell and have a wonderful evening. Until next time, thanks again.